Excellent. Okay, very good, guys. Good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. We are running 5 minutes late today. I had some issues with our communication equipment. It's all set now. I'm going to double check that you can hear me. Give me one moment.
The conference is now in conversation mode.
Can you all hear me okay now, folks?
Yes.
Yes.
Okay.
Yeah.
By the way, area code 248, put your hand down. We're not at the question answer sessions yet. Area code 248, just press *5. No questions yet. Sit down. Okay, thank you. All right, here we go.
The conference is now in presentation mode.
Okay, so folks, this is our bi-weekly telephone call every other week. We hold it every other Thursday, and the information supplied is subject to the disclaimers you would have heard when you logged in. I'm going to go over our frequently asked questions first. As a preliminary matter, I want to note there was a question about a U visa and political asylum. Those are not our areas of practice. Our practice is very heavily focused on employment-based, business-based, and relative immigration, especially complicated cases as well as litigations associated with them. Okay, so let me do the frequently asked questions first. After each question, I will ask for any follow-ups. If you have a follow-up question on what I'm talking about, feel free to ask. Otherwise, wait till the end of the call. We have time remaining. We will go over new issues. Okay. First one is, this is a very common problem. My surviving parent, mom has passed on or dad has passed on, is alone in their home country. What is the best option for them to come here? So obviously the tourist visa is an option if they want to come here temporarily. But if they want to come here temporarily and they want to convert to a green card, that can get a little tricky. What you want to make sure is that when they start from their home country and when they land and enter the United States, they have no intention to convert to green card. That's important. Otherwise, the government can consider it a fraud in the procurement of the visa and a fraud in the use of the visa. Okay. After they've been here for about 90 days, after 90 days, I would say even maybe 4 months, because typically they get 6 months stay. After they have been here 4 months, approach your counsel, or if you're going to do it yourself, it's not complicated. You can do it yourself as well. You can apply for their green card. And while it's pending, they can stay here. Might take about a year and a half for the green card to be processed. In between, they'll get advanced parole based upon which they can travel in and out while this process is going on. If, however, they travel outside without the advanced parole, then the I-130 goes on and it can be converted to consular processing, so they go for interview in their home country. But the 485 is deemed abandoned. The 485 is deemed abandoned. Okay? So that, I think, is the best thing to do. If temporary, bring them in on a tourist. If not temporary, if they want to stay here forever, do not start with a preconceived intention. See how things develop after they've been here 4 months. You can bring that issue up. Okay. *5, if you have a follow-up question on this, folks. *5. Okay, just for the information, the people who are logging in, I am planning not to have these calls for 3 weeks because our office is so busy. Plus, we have a litigation going where I think the government is going to fight me. So we're going to be busy. So I'm going to stay back and try to answer as many of your questions today as I can. Okay. After that, of course, you can still try to reach us. You have all those contact us form as well as help@immigration.com, my personal email address. I'll do the best I can, but I will not be able to come back to the community conferences until November. Okay. So the first question has been answered. There are no follow-ups. Let's go. Oh, by the way, to ask a follow-up question, press *5 on your phone. Follow-ups only, no new questions. Parents of U.S. citizens. That's the issue we are discussing. Area code 615. 615, go ahead, please.
Hey, so my question is only is a follow-up question only for the last part where you said that I-131 goes on. So are you saying that it is possible to apply for the advanced payroll from outside the US?
No, I never said that. I said if they travel out without an advanced parole, their entire 485 process is over. Okay? No, you cannot apply for I-131 from outside USM. Okay?
Okay, got it. Thank you.
You're welcome. Okay, yeah, that's fine. That's a good example of a follow-up question. I have no problem answering those. Reserve new questions to the end of our call, okay? Thank you. So this is, Romal wants to know about H-1B converting to H-4, back to H-1B, issues and options, things that happen. This is a frequently asked question also. So he was working on H-1B, got laid off because of the darn COVID nuisance. Now he's considering of going to H-4 within 60 days of the grace period. Question number 1, am I eligible to continue my job search when I'm on H-4? Absolutely, yes. You can look for a job even when the H-4 is pending or when the H-4 is approved. By the way, I do not know how many of you have seen my posting on social media, Facebook, LinkedIn, and Twitter. A government is going to introduce premium processing for H-4 and H-4 EAD as well. That's going to be, I think, no more than $1,500 each. And I think the turnaround time is about 30 days. It's not yet final. This is just a law passed. Government has to make regulations, which they might be doing very quickly. So under the new regulations, national interest waiver, EB-1C, H-1s, F-1s, H-4s, H-1 was already there, F-1s, all the non-immigrant visas, including B-1, B-2s, can be premiumed. So different fees. Look for my comment on LinkedIn, and I think Economic Times today also quoted me a couple of times. So this is how it's gonna be, and that's a good thing. I just don't think the amount of money they're going to charge is fair, but it is what it is. So yes, you can look for a job while you are on H-4, no question about that. You can also get a job offer, you just cannot start working. And you can use the remaining time on your previous H-1 to change back to H-1, and you would be cap exempt at that point. Can I change back to H-1 while H-4 is still under process? This is where the problem is. And this might become more of a hypothetical issue, because if premium processing for H-4 comes into play very quickly, you might be able to get your H-4 EAD within 30 days, right? That would be wonderful. So what I was commenting to, I think it was maybe it was the Times of India or Economic Times, one of our newspapers, that I think it's a lot cheaper than having to sue the government for the employment authorization. So yeah, I think it's a welcome relief. I don't think the amounts are reasonable. So this might become a rhetorical issue rather than something really that you need to worry about. So you cannot convert to H-1 while the H-4 is pending. That's what the government says. I filed a lawsuit against them, and they settled with me, giving my H-1 in very similar circumstances, because I thought their interpretation was unreasonable. And government obviously agreed with me, and they backed off, gave me my H-1. In fact, I was talking to that client today. So that was one success for the good guys. Okay, I'm just looking at the other question. 3, would I also need an H-1B visa to start my new job? You will not, because you will probably get a change of status. Our client did. He was in between statuses. Once something was pending, they gave him the I-94 within the United States. So when you have the I-94, you do not need a visa stamp to start working. But you cannot start working like you would if it was an H-1 to H-1 transfer. You will have to wait for the actual approval before you can start working. Can I retain my priority date from the old employer? Absolutely. How long can I retain my priority date? Well, interestingly, there is no limit. Not only the priority date, but even the I-140 approval once given is forever. Priority date remains yours even if the I-140 is withdrawn, as long as the withdrawal occurs on or after January 17th, 2017. Before that, the law is uncertain. And I think either I have an email or a question about this further down. Somebody said, what should I do? And because they've revoked and I can't keep my priority date, they did it before January 17th. I think there might be room for a lawsuit there. Look into it. You might be able to recapture your date. I think that has covered all the questions in this. I think we are good. So basically, you would be able to convert back to H-1B and start working upon approval. You should not need an H-1B visa stamp. Star 5. Any follow-up questions, ladies and gentlemen? Star 5. Okay. I've got one from area code 419. 419, where are you calling from?
I'm calling from Virginia.
Okay.
My question is, so if I'm waiting for my H4 approval, is there no way I can start working for a job? I mean, is there no way I can convert to an H1 while I'm waiting for an H4 EAD?
No.
For an H4 approval?
No. Short of
So I'll have to wait for
short of a lawsuit, there is no other way that I can think of. But like I said, this question may be more theoretical than practical, more rhetorical than realistic. If premium processing for H4 and H4 EAD is reinstated, many of you may not even want to convert to H1. Stay on H4, H4 EAD. Okay. Gives you a lot more freedom. You can hold 1 job, 2 jobs, 10 jobs, start your own business. You can do a lot more on H4 EAD than you can on H1. Make sense?
Yes. And how soon is that expected to be functional?
Hey, the government needs money. Okay. They were barred by court from raising the fees, and Trump signed this new law late yesterday or early Thursday morning, something like that. So it's just been done. I have a feeling USCIS is going to rush to get the regulations in. They might do it as early as in a couple of weeks, I suspect. So things should work out well for people who are waiting for H4 EAD situation. Okay. And remember, all of you guys, at least under today's rules, you can premium all the pending cases also. So there are so many people, hundreds of people approached me actually, 100+ group. They wanted to file a lawsuit. And I was very reluctant to file the lawsuit because I didn't think we could overcome the biometrics requirement. That was the tough one. And I think they did end up filing a lawsuit, and I'm not sure what happened. Maybe I don't think they won the lawsuit as far as I know. But this might become practically useless because we have the premium processing coming in. Okay. Go ahead with any other follow-up questions you have.
That's all. Thank you so much.
Good luck, sir. Okay, no further questions. Let's go on to the next frequently asked question. And once again, I just remind people who just logged in, guys, we may not be holding calls in October because we're so busy right now, but first week of November we'll start again. You can, of course, reach me in between. If there's an emergency of any kind, you can just send an email to help@immigration.com. I'll do the best I can. The way we work is we do as many free consultations as we can. We charge for some, especially if you can afford to pay. And we also, if I have a frequently asked question on this, I will send it to you saying, okay, well, just look at this. This takes care of your problem. Okay. But again, if things get under better control, I will come back and keep doing these calls. It all depends. Right now, things are pretty nuts in the office. We are busy. Okay. So let's go to the next frequently asked question. This kind of relates to what we were talking about. How long is my priority date valid? How long is my I-140 approval valid? And the answer to both of them is forever. And how many years can I wait to file 485 after priority date becomes current? Again, as long as you like. I had a call yesterday with one of our corporate clients, and they had all their employees on the phone with us in the conference call. And one of the guys there wanted to get married, but he didn't want to get married right away. So his question was the same. My dates are current. Can I continue to wait? And I said, yeah, there's no law that you have to file right away. But if the dates slip back again, then you have to wait for them to be current again. But if the dates are current today, tomorrow, next year, 10 years from now, you can wait 10 years from now. As long as the job is there, you can wait as long as you want. The questions from Papani04, from past 15 years, H1B, I-140 is approved, still active. EB3 date became current from 2018. Unable to file. Old company doesn't exist. Current employer Perm expired. Oh, that sucks. This is the reason. Okay. If I don't file within any time limit, will I lose my priority date or approved I-140? You should not. Now, remember one thing. There is a very odd law regulation on the books that says if the company goes out of business, USCIS can go back and revoke the I-140. But do you then lose the priority date? It's a little unclear. I personally think you do not. Okay. And I would fight in court for that right. I do not think that after January 17th, 2017, if they go back and try to revoke my old I-140 based upon the employer going out of business, I don't see how they can take away my priority date. Next question. Going to file H1 extension next month. I-94 is good till end of this month, October. Is there any chance I can get one more H1 extension when the dates are current? I looked at this. In my view, when the dates become current, you can still get 1-year extensions. If H1 denied or rejected, in that case, if I go to India, there is a rule there somewhere, guys. I kind of forget, that says you must apply for a green card within a certain period of time. But there is a little bit of a conflict between 3 different regulations. It should be examined. The last time I looked at it, my conclusion was that I can still get 1-year extensions. Okay. If H1 gets denied or rejected, in that case, if I go to India later, can apply for green card in Consular. In that case, once I-140 is approved, can I file through Consular process? Oh, absolutely. Absolutely. Yes, you can. Am I eligible for Consular processing? You are eligible for Consular processing, and you're not required to use the date. I do not know of anything. You may lose your right to extend H1s. And again, I remember that I think it was yearly still. I have to double check the regs on that. But you should never lose your priority date as far as I remember. So priority dates, they cannot take away, even if you don't file your 485 for 20 years. *5, if there are follow-up questions, *5. Okay, we're good. Sarah wants to know, can my green card sponsoring employer pay some parts or reimburse some amount of my grad school master's degree? Absolutely. Why not? The reimbursement, whatever the tax rules are, I don't see any problem with that. Oh, sorry. I started answering regular questions. Are the frequently asked questions done? Yes, they are. Okay, back to the very first question then. The frequently asked questions are done. Member 24, change my employer from A to B. After my Perm got approved with A is submitting my I-140. I wish to join them in the future. But my current employer is also starting the Perm. Lucky you. The question is, if the I-140 gets denied for any reason from the old employer A, should that be mentioned in the I-140 application with the current employer? Yes. Yes. I believe there is a question there that says, has anybody ever applied for an immigrant visa for you? And the answer is yes, because an I-140 is an immigrant visa application. Will it affect my H-1B? No. Will it affect my new I-140? No. Not unless the old or the employer A's I-140 was denied for fraud or misrepresentation on your part. So no, it should have no effect on your current case, H1 or green card. Also, in the Perm, does the 3-year of employment history, I don't know what that means actually. Does the 3-year of employment history start from the date of application? Are you on the phone? Because this question is not clear. Press *5 if you're here. Press *5. Tell me more about this because I don't understand this question. Let me take a look. You're not here. Another look. In the Perm, does the 3-year of employment history start from date of application? What 3 year of employment history? Example, if my perm is applied in October 2020, does the 3 years start from October 2017? Oh, I think what you're asking me is when is the experience frozen? So yes, on the date you apply the perm application, October 2020. So the perm experience continues to be accumulated until the date of filing. Okay, the moment you file the application, your experience is frozen. After that, your perm could be pending 7 years, hope not, pending 7 years, but that 7 years can't be counted towards that perm. Okay, star 5 if you have a follow-up question on this, star 5. Okay, area code 949. 949, where are you calling from?
I'm from California, Rajiv.
Yes, sir. Go ahead.
Thanks for your help on this. I have a similar question. I mean, obviously in the same multiple employer filing green cards question.
Yeah.
So my current employer, with my current employer, I have approved EB3 140, and it became current in August. We filed 485.
Good.
However, in parallel, I was having another I-140 going with employer B.
Okay.
That I-140 was approved after filing 485.
Okay.
Does that have any impact on the current 485?
Zero impact. Okay.
Even with the priority date quota, right?
Look, I can talk about this for the next 1 hour. The answer would still be the same, zero impact. Okay.
Yeah. The only reason I'm asking this was, my case got transferred to NBC, saying, visas are not available in this category in EB2. However, my category was EB3 but 485.
Yeah,
right?
that can be an error because they do data sweeps periodically, and they assign to you the most advantageous category, and usually that is the highest category with the earliest priority date. So that could be just an error. I don't see how that can impact your case. Okay.
Yeah. Okay, I'll reach out to them.
Yeah,
Thank you.
get that corrected. No, not a big deal. Okay, let's go on to the next one. And this one, again, I was not able to figure out. H1 eagerly. My H1 was approved in 2017. I didn't go for stamping. But I was able to transfer to employer B recently. Okay. My worry is, if I go to stamping and get denied, can I still use A? Who's A? A is an expired one for cap exempt. Okay, I'm not sure I understand this. I kind of sort of think I do. But typically, it has been the government's position, in order to be outside the H-1B quota, you either have to go get a visa stamp or you have to get a change of status to H-1. Okay. I have been able to get quota exemptions even where these two things were not done. So somebody had an H-1 approval without a change of status, did not go for visa stamping, continued on their L1, but we were able to transfer just like you were able to transfer to another employer. Now, if the employer B's visa outside USA gets denied, can you use that old employer's approval? I think you can, just like you were able to change to B. I would argue that upon approval of my H1, I'm quota exempt. I don't have to do change of status or visa stamping. Would it succeed? I do not know, but certainly that would be my argument. So far, it seems to be working. Star 5, if you have a follow-up question. Star 5. Okay. Oh, there is a follow-up question. Let's see. Area code 469. 469, where are you calling from?
Hi, I'm calling from Chennai. We are text now.
Go ahead.
Okay, so the question is, so as I have never traveled to USA. So I'm from India only.
I see.
So the saying is like as I told in the question, so I never traveled to USA. From employer A, I was able to transfer to employer B without stamping or traveling to USA.
Mm-hmm.
So I will be going for stamping when the consulate opens.
Mm-hmm. Yeah, so the answer is still
So
the same.
in
The
case
answer is exactly what I gave you. Government will say you are not quota exempt,
okay.
but we've been able to get transfers. I think you will be quota exempt. Let's see how it develops. If they deny, you are still in the same
My
position.
doubt is
Hang on.
okay.
If they deny, you are still in the
Okay,
same
okay,
position.
okay,
You can say I'm still exempt because of
okay.
earlier approval. Okay. So it's a question of
Oh,
arguing.
okay.
It's not a clear cut answer. Okay.
Okay. So what I was worried was if they deny B, will they revoke A also? That is what my worry.
Well, how does that matter? Whether they revoke or not. Bottom line is, are you quota exempt or not? And according to them, you are not quota exempt. Whether it's A, B, C, or D, because you never got visa stamping. Okay. According to me, you are quota exempt. So let's see who wins.
Okay.
All right.
Yeah, but I have
Sir,
already transferred without.
Yeah, sir. I have answered your question the best I can. Okay. Good luck.
Thank you.
You're welcome. Yeah, guys, you're gonna have to be a little succinct and move on because I gotta answer other people's questions also. Okay, let's see. Area code 848. Okay. 848. Go ahead, please.
Hi, Rajiv. This is Balaji. I posted the question number 8 regarding the priority date from 2004. I'm not sure if I missed the answer. I kind of heard
I haven't gotten
rule is
to
ambiguous.
hang on.
Oh,
I haven't gotten to 8 yet. Stay on the line. Okay.
okay.
Yeah.
Thank you.
Yeah. So let's see, where are we? We just did this one. Now we are on question number 5. My perm got approved. Oh, somebody still has their hand up. Area code 612. 612, where are you calling from?
Hey, sir, I'm from Reno, Nevada.
Yes, sir. Okay.
And I have very, just into the current situation when the visa bulletin has put the EB3
I'm not doing new questions right now. I'm only doing follow-up. Stand by. Now, don't ask me new questions, guys. I'm trying to finish up what I have on my plate first. The question number 5 is, my perm got approved with 2010 priority date. Employer applied 140 within 180 days, but the fees was incorrect. They have applied again, and this might have been a suitable case for a lawsuit because I think the regulations are murky, and when you have filed the first time around, yeah, but filing without proper fees may not be considered to be filing at all. Okay, whatever it is. So in the meantime, you started a new I-140 and etc. etc. So you want to see if you can get the old priority date. Have somebody study this for a lawsuit. I don't know off the top of my head, and right now we are pretty busy. I won't be able to look at this until November. After October is over, I can take a look at it if you want us to. We'll let you know what we will charge to just review the regulations. It shouldn't be too much, maybe an hour of my time. I'll take a look at the regulations, the memoranda, and see if there is any way we can shake this tree and get the government to listen to reason and try to restore your priority date. But that was never approved, right? That I-140 was never approved. We can at least ask them to reconsider. We can see how it works out. But I think it's a long shot, okay? If the I-140 had been approved somehow, it would have been a much better case for you. Star 5, if you have a follow-up question, star 5. Press star 5 on your phone. Okay, let's go on to the next one. This is number 7. My priority date is... Oh, guys, you have to be a little quick, okay? I keep coming back to... Area code 916. Where are you calling from?
Hi, sir. I'm calling from California.
Yes, sir.
Yeah. Sir, so I'll make it, I'll be very succinct about my question. So my wife moved back. You answered this question in one of the previous forums. I just wanted to get a clarification. So my wife moved back. So my wife works for an employer A. She changed locations from location 1 to location 2.
Stop. Does this have anything to do with what I just discussed? I'm only taking follow-up questions, guys. Stand by. I will make sure I answer everybody's questions because we are not going to meet for 3 weeks after this. So right now, please work with me.
Sorry.
Only ask me follow-up questions. Okay. I will stay back and I will answer all your questions. Okay. So going back to, this is very interruptive. Please don't do that. My priority date is November 2010. I-140 got approved in June next year. I've got H-1B extension of five times. Current H-1B is expiring September 30th of next year. Last year my wife went to India, got it stamped in Mumbai. Got what stamped? I guess H-4. I'm with the same employer since my first H-1B approved. Oh, they are planning to cut your salary 50%. Oh yes, definitely it has an impact on your green card and your H-1B. First of all, I'm not sure it's legal. I think it's illegal for them to try to do that. They can never pay you below the prevailing wage. And if they are going to do a substantial cut, they should be thinking about doing an H-1B amendment. Okay, and it can affect your green card too, because if the employer's pay cut reflects on their ability to pay your wages for the green card, it can lead to a subsequent green card denial at the I-140 stage. You've got the I-140 approval, but they can always go back and ask you the same questions. Why? Because technically, the ability to pay wages must be maintained till the date your green card is approved. Okay. Then, can I look around for a new employer, get a transfer? Do I have to apply for a new I-140? You have to start a new green card all over again, but you should be able to keep your priority date, no question about that. Current title is Operations Research Analyst. Can I do any job? Oh yeah, you can. The priority date can be transferred across any job. So if you have a degree in medicine and a degree in computer science, your one job could be as a doctor, as a physician, and your second job could be as a systems analyst. That's fine. You would still carry your priority date. I have reached the age of 65 and I can get Social Security benefits. Does this affect my green card application or H-1B transfer? I do not know. I haven't looked at it, but I don't think so. Because Social Security benefits are something you paid in for. Have this double checked. I don't claim to be an authority. I have to look at the law. These public charge provisions are still new. They just started a few weeks ago. We are still learning them bit by bit by bit. But I don't think Social Security should be a problem. Can I go to India for 4 or 5 months without pay and return to USA, not on H-1B? That would be a problem because the government could say that it doesn't look like that same H-1B was being maintained. If you want to take an unpaid leave of absence for reasons unrelated to your employment, you certainly can. But if you are going because you don't have a project or don't have a job that pays the H-1B salary, that probably won't be allowed. And you'll be considered to be out of status, which means you must get an H-1B visa stamp and come back in. Okay? *5 if you have a follow-up question. *5. Okay, let's take this question. 212, I think, is New York, right? Hi, 212, where are you calling from?
I'm calling from New York, you're right, sir.
Yes, sir. How can I help you?
Now, after I posted this question, visa bulletin came, and now I'm eligible to file my 485.
Okay.
My company is also going to do amendment to H-1B regarding my pay cut and other things.
Okay.
So, does this Because see, my priority is pending for, see, we are working with the same company for so many years. They kept on me with a good salary. Now, because of this COVID-19 situation, everybody wants to cut down the cost.
Sure. Yeah, see, the only problem I see, sir, is that when a company cuts down the salary, are they still able to afford your green card salary, which is to be paid only after the green card is approved? Nevertheless, the ability to pay must be demonstrated on an ongoing basis till you get your green card. So that's the only question. You should discuss with your lawyer, sit down with them, parse through the numbers, look at the company's tax returns. If their tax returns are problematic, make sure they can leave some retained earnings, some money in the bank at the end of the year, and that would help. So make sure that you plan for it. I'm hoping that it won't be a problem for you, but that's one problem area that I see. Okay?
Okay, sir. Thank you.
Oh, you're welcome.
Thank you.
Good luck, sir.
Thank you.
You're welcome.
Thank you.
Okay. Next question. This is question number 8. I have an approved but withdrawn I-140 with date of 2004. Wow. Approved in 2008, withdrawn in 2009. Left to India for personal reason. Yeah, I don't remember what the regulations were in 2009. You have to look at the 2009 regulations, whether or not they allowed you to keep your priority date if the I-140 was withdrawn. I don't remember. So have your lawyers look at the 2009 version of 8 CFR, is it 204? Yeah, 8 CFR 204B, I think, to see what the preservation of priority date provisions at that time were. You applied under EB1C, but all this may be irrelevant because the dates are getting current, right? So yeah, I don't remember the regulations back then, sorry. Okay. You should certainly have them looked at. *5 if you have a follow-up question, *5. All right, let's see what we have here. Area code 848. 848, where are you calling from?
Hi, Rajiv. I'm calling from New Jersey.
Yes, sir.
Yeah, I posted this question. Thanks for your response. I'll have them look at what was the regulation in 2009. I think it is 204 CFR was the reason quoted.
Yeah, 8 CFR
I'm just trying
204.
To see I'm trying to see if there is any life left in this. There was I-485 pending for nearly 3 years at that point of withdrawal. So I came back in 2000.
Hang on. You said the 485 was pending for 3 years?
Yes, the 485 was applied in 2007 concurrently. So at the time of withdrawal, it was almost 2+ years.
I think you would be protected by AC-21. I think AC-21 came in 2000. So therefore, you should be protected by, I think you should be protected by AC-21. Priority date should be yours to keep, I think. Okay.
Okay. So I have a new I-140 that's applied under EB1C.
Right.
I'm just trying to see if once that gets approved, I have applied with the old I-140 as well. I'm waiting to see if once they approve, do they give me the 2004? If not, what should be my steps?
Have your lawyers look at it, or catch hold of somebody random like us. We can take a look at it. If we have the time, we'll be happy to review the law for you. We can look at the historical, because see, the online databases, they maintain almost unlimited versions of the regulations. So we can go back in time and look at what the regulations were, what the court interpretations were, and see if there's any way to restore your priority date to you. Okay?
All right, great. Thank you, Rajiv.
Oh,
I think
welcome.
this helps a lot.
You're welcome. Good luck. Good luck. Okay, Aurora says, thank you for addressing LPR stuck abroad over a year. I'm unable to call in. So I have 3 simple follow-up questions. So the problem is, airlines are not just allowing people to board even though they are allowed to board. I don't know what to do about that. I think if the airlines are local, and this sounds kind of silly, but maybe going through local politicians to talk to these airlines, and even the aviation minister or minister for transportation, whatever they are called, have them talk to these aviation people and say, you guys shape up. Why are you not letting people board? And I think you could even file a lawsuit locally. There might be a potential for a lawsuit. I don't know if there's a writ for this, but there definitely should be an emergency petition of some kind. So I would go to a politician first, and then I would go to probably go to court over this. Local courts in India, if you're in India. The US Embassy indicates that even an expired 551 is enough. Well, no, wait. Don't confuse. There are two different things here. Okay. Let me explain to you how this whole area of law works. Expiration of a green card is not a problem. You can always get a travel foil or a travel letter from the consulate and travel on an expired green card. That's a minor issue. But if you are outside USA for 1 year, even if your green card is valid for 20 years, you cannot board a plane. At 1 year, your green card got automatically cancelled. So the airline cannot let you board. They'll get fined if they let you board. Okay. Next question is kind of related to what I just said. And remember what I just told you. If you are able to board, even though your green card 1 year has expired, the Customs and Border Protection might let you enter based upon certain documents, etc. But I don't think airlines will let you board. I have never known anybody to be able to board after they've been outside USA for 1 year. Expired green card is a minor issue. Last question is, if you're waiting for a green card process, can you get an F1? You can certainly try. I've gotten tourist visas while the green card was pending. But it's not guaranteed. It all depends upon the consular officer. Here's what I can argue if I were you. If somebody is very career-minded, and I had a case like that. I had somebody who was a physician. Somebody is very career-minded. Their career shouldn't have to suffer because they are waiting for a green card, especially if their back history shows they've gone to good schools, maintained good grades, they're serious students. So yeah, it's theoretically possible, but highly unlikely. Since you're not able to log in, I'll just double check anyway. *5 if you have a question, a follow-up question. Okay. Dhruv wants to know, if I get an EAD under compelling circumstances, can I still maintain an H-1B? Okay, the H-1B doesn't get destroyed, it just gets suspended. So if you got a compelling circumstances EAD and you worked 3, 4, 5 months and you said, you know what, I want to go back on H-1B, just travel outside USA and come back on an H-1B visa. If you have an existing visa, all the better. Okay, easy enough. Somebody raised their hand kind of in between, so I don't know what's going on here. Area code 716. 716, where are you calling from? 716, where are you?
Hey, I'm calling from California.
Yes, sir.
I just have one question is that after getting the 485 EAD, right, do I need to renew the EAD every time till the time I'll actually get my green card? Or I can continue to be on H1?
You have to keep renewing your EAD. But yeah, you can also, wait. You don't have to apply for an EAD. You can just continue on H1B if you like. Okay. So when you are on 485, hang on, sir. Let me finish. When you are on 485, you can simultaneously and concurrently hold an H1B without applying for an EAD. Okay. By the same token, if you have applied for one, you're under no obligation to renew it if you're going to continue using the H1B. Okay.
Okay, thank you.
You're welcome. Next question, applying for parents, US citizen applying. This is question number 11. US citizen applying for parents, early Feb, passed the final public charge rule. Oh, no. That nobody is on hold anymore. You have to file 944. Okay. You need to submit 944. If you go to the USCIS website, it tells you that mid-September they won in the Court of Appeals, and now they are asking everybody to submit their 944s, including people from Vermont, New York, etc., etc. Okay. *5 if you have a follow-up question. *5. Okay. 13 I had answered already, that your employer can reimburse your fees, graduate school fees. Wally wants to know, this is number 14, can I file change of status H1 to F1 as well as H1 extension? You can, but whatever is approved last would be your status. No, let me rephrase that. But H1 to F1, you will be on F1 eventually, because if the H1 extension is still pending and you get an F1, then you're on F1. Although pending applications, they may not give an F1. So be careful. It can cause some unintended consequences. Certainly it can be done. It's legal. And you should. And by the way, like I said, they're going to premium the F1s too. So maybe you could get an F1 approval within 30 days after they implement the regulations, which might be very quickly. So do this, Wally. File them both. Okay, file them both. And if one gets approved, let me rephrase that. H1 extension gets approved, it's no problem. F1 gets approved, withdraw the H1, it's no problem. That's the simplest thing to do. *5 if you have a follow-up question. So once again, file both. If F1 gets approved, withdraw the H1. H1 gets approved, extension gets approved, no problem. Keep waiting until the F1 is approved. That's simple. Gilbert, that's I think the last question. And then we'll do the new questions after that. I have a quick question regarding my non-immigrant visa. This is number 15. I had my 3-year H-1B visa stamped, valid till 2020. Passport was expiring in June. I renewed my passport. I-94O was also expiring in June 2019. It was realized only in March 2020. Oh, so you got extension, Nung Pro Tunk. Very good. 3 years from August 2020 to August 2023. What happens to the period between June 2019 to August 2020? Well, this is a suspenseful situation. Personally, I think you are fine. Okay. I think you are fine. You should still try to get Nung Pro Tunk so the 2019 to 2020 period is covered. Even file a motion to reconsider, reopen, discuss with your lawyers what is the best option. If not, I wouldn't want you to travel until you get your green card approval. It's a little bit of a suspenseful situation. *5 if you have a follow-up question. *5. Okay, any question, guys? *5. Any questions? Let's see. 6 so far. 9 so far. 9 people have questions. 10 so far. 12, 13. 13 people have questions. Okay. I was wondering if I should take a little break, but I guess not. We'll just keep going. I'm just opening randomly whatever number I see in front of me. Area code 916. Let's do 916 first. Let's see. 916, go ahead, please. Where are you calling from?
Hi, sir. I'm calling from California.
Yes, sir.
Yeah. So my situation is my wife has an has an I-140 approved on EB2 back in 2013, and she was working in a location A for an employer A. And then recently in 2018, she moved to a location B with a different job title.
Okay.
So the company has again filed Perm, but before they filed an I-140, she moved back to her old job, like the same job, same location that where the I-140 was previously approved.
Okay.
My question is now that the the EB assuming her EB2 date is current right now, can she use the previous I-140 and file for I-485 because it's the same job location, it's the same job title, same project, same team that she moved back to?
Not having seen her labor cert, my generic theoretical guess is absolutely she can, but have her lawyers review it carefully. I don't see any issue.
Yeah, because it's the same employer, same job title, same salary range, same location that she moved back to. But I think her immigration might have not checked her previous status, and they started filing a new perm.
Yeah.
So that is where I have a question.
It doesn't make any sense to me. You want to set up a consultation? We can set one up for you. I have to review the case, but frankly, I don't see any need for it. This doesn't sound that complicated.
Got it.
Okay.
Got it, sir. I think thank you. I think you answered this question in a different way in one of your previous forums, and thank you for confirming.
Oh, you're welcome. Good luck.
Appreciate it.
Good luck.
Thank you.
Okay, let's go to area code 860. 860, where are you calling from?
Good afternoon, Rajiv. Thanks for taking my call. My question is for my daughter.
Where are you calling from? I always like to know that.
I'm calling from Connecticut.
Connecticut. Okay, go ahead, please.
Yeah. So, Rajiv, my question is for my daughter. We have filed for her H4 to F1 transfer in March 2020.
Okay.
But afterward, because of the COVID, we didn't get her biometrics and all, so things were delayed.
Okay.
So, meantime, in July, she aged out. She turned 21 in July.
Okay.
And now I got a RFE from the office.
Okay.
And the RFE says I-20, the savings program start date elapsed.
Right.
So she's already in her final year of the graduation.
Okay.
So we reached to school for the new savings with the same number.
Right.
So what should be the date of start for the new savings?
The school should be able to guide you realistically because her application is now being considered. I would say about you see, she has to maintain status still within 30 days of the start time. So check with the school what is the next, I would say, check with the school. They might be able to better guide you what the kickoff date on the next semester is. And you can time response to the RFE because you have 87 days, right? You can time your response according to the school's suggestion. Okay?
Okay. Because currently we had one discussion with the school counselor and she's giving the new start date as January 21. But is that and will that be an issue if she gives me the savings of January 21?
See, my problem is, when did she age out? What date did she age out? Sorry?
July 28th.
Yeah, she's already out of
July 20th.
She's already out of status. They may not give her an F1 because once you're out of status, but then her F1 is pending. This is a difficult situation. This is not a clear-cut situation. Okay? The school said they're going to give it from January.
That's what they indicated, but we have a follow-up meeting with them.
Well, the problem I have with January is, when is your response due?
Response due in, I think, next 3 days, Monday.
Even with that additional 60 days and all?
I don't think they gave us a 60 days. I think I got our
but look at the USCIS website. Haven't they added 60 days to every response? They have.
You have to check.
Yeah, double check it.
I didn't know about
because
that.
Of COVID, everything that was issued, I think, between June and September has an automatic, or maybe even December, has an automatic extension of 60 more days.
Okay.
The reason I'm asking that is that will bring you close to January. Okay?
Right.
So maybe that's the way to go.
Okay.
All right.
Thank you, Rajiv.
Good luck. And also, you must have heard that they are going to start premiuming F1s. So maybe that's something to be kept in mind as well. Okay?
Okay. Got it.
Good luck, sir. Okay, let's see who's next. Sorry, guys, I had to make some tea. I'm really very busy day. Started like 4 o'clock in the morning. 614, area code 614. Who is 614, guys? Where are you calling from?
I'm calling from Melbourne, Australia.
Yes, sir.
My daughter is an Australian citizen, going to marry an Indian citizen working in US, in H-1B visa. The marriage will be next year, April 2021.
Okay.
What is the best way to get US green card for both of them?
But she's not born in Australia, is she?
No, she's born in Australia.
Oh, if she's born in Australia, that is like a gold mine for him. There is you can note down the technical term. It's called cross chargeability.
Yep.
So you know that, right? So now what will happen is his green card will become very much accelerated, his employment-based green card, because he can be charged to Australia after the marriage.
All right. Okay. Yeah.
Okay. So so the best green card option is employment-based green card with cross chargeability.
Cross chargeability. Okay. All right. Okay. So that means where do we apply for this?
This is not complicated. The lawyers we do it all the time. All you have to do is, when we file the last step of his green card, we indicate to the government, this is a cross chargeability case. Don't charge it to India, charge it to Australia. Give me my green card right away.
I see. Okay. All right. Okay. So I need to go through some of the lawyers to get this one done, or can I do it myself?
Employment-based green cards should never be done without lawyers. They should always be done through lawyers. Okay?
All right. Okay. All right. Understand. Okay. All right. And one more question in there. And they are going to get married here in India or in Australia. Does it make any difference in the green card process?
Zero difference.
Marriage registration?
No difference.
Zero difference. Okay. Thank you very much.
You're welcome. Good luck.
Thank you very much, Rajiv.
Good luck. Congratulations.
Good luck.
Okay. Area code 585. Where are you calling from? Let's see. Wait. Not yet. Wait. Yeah, 585. Where are you calling from?
I'm calling from Virginia, Rajiv. Thank you.
Go ahead, sir.
Yeah, so my wife was working from 2016 to 2020 in H4 EAD.
Okay.
Then, her employer filed for her H1 in March, which got approved.
Good.
But then after 6-7 months, they got a notice for revocation of H1 because her previous employer, which filed the H1 7 years back, was kind of involved in the fraud.
Okay.
So I'm a little bit worried, like what do I do in this case, in case her H1 gets revoked?
Okay.
Should I move her to H4 now?
Absolutely.
I'll pause if you want.
Absolutely. This is what you should do. When is the deadline to respond to the notice of intent to revoke?
So my understanding is normally it was 30 days, but because of COVID, it's 60 days extension has been given, so it's 30 plus 60.
Exactly.
So it should be somewhere in December time.
What I want to do is do nothing for now. Okay? Wait until you see, or you can do it this way also. You can file her H4 right now. H4 and H4 EAD right now. file it. The moment you see premium these.
Okay. But then the follow-up question I have is, her company is going to fight the case, is what her company
Let
is doing.
them fight.
Because they feel that...
Let them. I agree with them. I would fight the hell out of that. I actually had a case where they tried to... A client came to me after getting their naturalization denied because 9 years ago, their company owner had been in some kind of an issue with the government. And so I said, no worries, we'll appeal the case. We appealed the case. I went to the appeal. I talked with the officer and I said, why am I responsible for my employer's fraud? Did you charge me? No. Is there any allegation against me? No. Then why are you coming after me? Leave me the hell alone. I've not done anything wrong. That couple were so scared they were willing to move to Canada because they have 2 kids. I think they were 8 and 13, who had lived all their lives in USA, US-born citizens. They wouldn't know what to do in India. So I said, wait, before you start packing your bags, I'm not done with these guys. So they can make any allegations they want. Just because they allege something doesn't mean it's true. So yeah, I would fight the hell out of that.
Okay, so then my last follow-up would be, in worst case situation, if the H1 after the company fights and it gets revoked, does it mean that if my wife goes out, she will never get an H4 stamping?
She's not done anything wrong. Why would she? See, unless there was some charges against her personally, I would like to see them try to hurt her. They cannot.
Okay.
Don't worry. Sit tight.
Okay.
This is going to be okay.
All right. Okay. Thank you, Rajiv. I really appreciate it.
Absolutely.
Thank you so much.
Good luck. Yeah, guys, we're not without teeth. You know, when the government is unreasonable, they can be challenged on it. Area code 615. 615, where are you calling from?
Hey, Rajiv. Thanks for doing this. I'm calling from Philly.
Mm-hmm.
The adjustment of status EAD and advance payroll, earlier that it is okay to let those things expire.
And just continue on H1B. Does that affect anything when your PD becomes current in the final chart? And if you want to extend, keep on renewing those things, how much in advance, how many months in advance should you renew those things? EAD.
Okay, so the problem with EAD and advance parole is their times are going crazy. Okay, it can take 8-9 months, and I know that EADs are going to start getting premiumed. So I don't know how far they're going to extend that. Are they going to include APs in that? The problem is when you have to travel. So given a choice, and let's say I don't want to spend money on keeping my EAD extended, just extend your AP. I think advanced parole is good to have. Okay. So, all right.
Okay. Can I ask one more question? Thanks. So if my wife, she has H4 EAD, and at some point if she ends up using her AOS EAD, the adjustment of status EAD, does it invalidate her H4 and H4 EAD, and does it have an impact on my H1?
Well, at one time, first of all, no impact on your H1B, but at one time, I am not sure you are allowed to keep more than one type of EAD. So it may well be, and I don't remember how they are doing this, but I would not use my H4 EAD at all. I would just use my I-485 EAD. It's a much stronger EAD. One, you can extend it 180 days ahead of time. You can apply for extension. Second, unlike H4 EAD, once you filed an extension, you can continue working up to 180 days after the expiration. H4 EAD, you can't do that. You got to stop. So yeah, work on your 485 EAD only. Okay.
Okay.
You're welcome.
Thank you.
Let's see. Next one is 408 is California. I know for sure. 408. Go ahead. 408.
Thank you, Rajiv.
This is Narendra from Sunnyvale,
yes,
California. My question is, can I file 485 with my previous employer, because just 5 months back I got an offer and got a new employment with the new employer.
And
And is my, with my previous consular form okay if I can I file 485 with them? And also second question is there any premium for filing 485 just like 140? Thank you.
You're welcome. No, there is no premium for 485 right now, nor is there likely to be. But can you go back to the old employer? And the answer is yes. But listen to the audio that I have recorded. It's on LinkedIn. It's on my Facebook page. I have tweeted about it as well. There are a couple of issues that should be resolved, but yeah, definitely you can do that. Discuss it with your lawyers and go for it. Okay?
Thank you.
Thank you.
Good luck. Let's go to area code 720. Where are you calling from, 720?
Hello, thank you.
Hello, thank you, Rajiv. This is Pooja from Centennial, Colorado.
So actually,
we are US citizens and married for last 11 years. We don't have any kid.
So we are
planning to adopt my newborn baby nephew from India, from Jalandhar.
And
it's my brother's second boy, and both biological parents are physically and financially healthy.
So we did contact
adoption agency in Colorado, and they refused to take our case. They said like you are not fall under criteria conventional adoptee, so your I-800 will not get approved by USCIS.
I haven't done adoptions in a few years. But from what I remember, there are two kinds of adoptions. Well, there are three kinds of adoptions. Adoption when you are a non-immigrant visa holder, that's a little different. H1, H4, L1, L2, different kind of adoptions. When you are a US citizen, you have two choices. Depends upon the country you're adopting the child from. There are Hague Convention countries and there are countries that have not signed the Hague Convention. India is a Hague Convention country. If you Google India Adoptions Hague Convention, India actually has an office of adoptions with plenty of frequently asked questions. Review that, and also the US State Department has a complete section devoted to adoptions. Review that. From what I remember, the way this would work is they would have to give the child up for adoption. You would then have to adopt the child from the orphanage or wherever the child is. Something like this, and I don't remember the details. Look into it. It's possible, but it requires certain steps. You cannot adopt directly from the parents, I think.
Okay.
So
there is another thing. If that doesn't work, like agency is refusing, they said like we cannot take your case. So in that case, what we were thinking, me and my husband, we have the only option left that maybe we have to go back to India. And can we do domestic adoption there? Like we can stay there for 1 year and then we can take the legal custody and stay there for more 2 years and file I-130 for the baby.
Poojaji, I think you can, but I don't remember the details. The law about being in custody 2 years certainly works for non-immigrant visa holders. Does it work equally for US citizens? I do not remember. I would have to have that checked. See if you can find an attorney who does adoptions. We stopped doing these because most of them didn't require a lawyer. They were done through adoption agencies. Lawyers were not needed, so we kind of backed off of these. So I don't know, my knowledge is a little outdated. I know that procedure is available for all the non-immigrant visa holders. I would suggest you can talk with some lawyers, etc., who do these. We'd be happy to look them up for you, but I just don't have the time this month. Okay? We're just taking... You're welcome.
Thank you.
Good luck, Poojaji.
Thank you.
Thank you.
Okay, so... How the heck do I do this? Okay, done. Now, area code 407. Where are you calling from, 407?
Hello, sir. I am from Florida.
Yes, sir. How can I help you?
Yes, sir.
Yes, sir.
Actually, I am on EB3 with the priority date of July 2013. And as per the October bulletin, I am going to file my application. The issue is my son is aging out in February 2021. And he's still on H4, but he was planning to convert his status to F1 before this October bulletin. So my question is how to proceed that. Like if he decided to go with F1 because we still have 2-3 months to convert H4 to F1. So later if he decided to go with F1 right now, so later after a couple of months, suppose my action date becomes current, so will he able to file his application as a family application along with us, or how to proceed?
Okay.
That?
So,
or is it good idea to file his application along with us?
Yeah, I think you should. Okay. One thing I want you to be aware of, the Child Status Protection Act, there's a lot of echo in the line.
H-1B is expiring on September 11, and my employer they filed for extension, and they had this lot many contracts and other stuff because I paid around $4,000 in India as a contract, and still their new off letter was having that. So I just wanted to get away with that, and then I transferred my visa to the other company, and then it's got approved for 3 years now. So now I resigned there, and now they are trying to ask me the H-1 extension fees and all that. So I went through your older videos. So I know that it's illegal, but is it still gonna illegal, or is
It's
that rules
very
changed?
illegal. Yes. You can let them know that you intend to call the Immigration and Custom Enforcement and report them. They'll all go to prison. Okay.
And on the next, shall I have one more question, please? So the other question is they when they signed this agreement and all that, so they were asking to not to join any clients or any vendors which I'm currently working. So if I join, then do I face any problem?
That's a contract issue. You have to talk to a contract lawyer. If they are not clear about any immigration aspects, they can talk to me. Just let your contract lawyers know, but that's a contract issue. Okay. I think the whole contract contract is illegal. So just talk to a contract lawyer. Okay.
Okay. So I can just email you guys, or I can connect with you guys, right?
Absolutely.
Is that fine?
Good luck to you, sir. All right.
Okay.
Bye-bye.
Yeah.
You're welcome.
Thank you so much, sir.
You're welcome.
Thank you so much, sir. Yeah.
Okay. Area code 631. 631, where are you calling from? 631.
Hello. Hi, Raju.
Hello. Hi, Raju.
Yes, sir, I can.
Hello.
I can hear you.
Okay. Good afternoon.
Okay. Good afternoon. Good afternoon. I have a question on EB2 to EB3 downgrade and concurrent filing. We filed concurrently on EB2 I-140 using EB2 Perm. I have a question on negative side. If something happened to EB3 I-140 means denied, what will happen to my EB2 green card status and H-1B status?
That's why the EB2 should be very carefully reviewed. Sometimes there are issues. Today I found one issue with somebody's filing. They had asked for a consultation. I told them not to file. I told them to start their green card all over again and hope to keep the priority date because there was an error. Some of these errors are because the way the Department of Labor thinks about these cases has changed. Some of these are just errors that can come because of human faults, and some of these errors are just bad lawyering. So make sure that your case is carefully reviewed, because if there is a problem with your EB2 case, it will surface they will revoke the EB2. Be careful with that. And that can also affect your H1B extendability. Okay?
Okay.
Thank you.
You're welcome.
Thank you.
Okay. Area code 916, where are you calling from?
Hey Rajiv, this is from California.
Yes, ma'am.
I have two questions actually. From the October bulletin, our priority is coming under date of filing. So what's the difference between date of filing and final action date?
So the visa bulletin contains the final action dates. But sometimes the calculations that the State Department does based upon visa issuance at the consulates and the USCIS does based upon adjustment of statuses in USA, the numbers may be different. When USCIS believes they can accommodate more cases, they let you use the USCIS dates, which are called the dates for filing. Okay? But they are only available for cases only available for cases filed in USA, not for consular processing.
Okay, yeah. And then if I'm filing for adjustment status now, and my daughter is in junior high, next year we're going to apply her for college. So until then, if I didn't get any adjustment status, can I put her in college as H4 dependent or F1 student?
Once she's 21, she can no longer be H4. The Child Status Protection Act will protect her not based upon the filing date, but the final action date. So if the final action date becomes current while this is pending, I believe she will then be protected by CSPA. But you can't rely upon the filing dates to protect her. Okay? So what you would do is you would apply for F1, which is difficult to get when a 485 is pending, but not impossible. However, she should be able to go to school on the 485 itself.
Because I have 4 more years till 10, 21. So
I don't think
final action
it's
date
going to be a problem. I think you'll be fine. Okay. Oh, you're welcome.
Thank you, sir.
Good luck. Okay, area code 913, where are you calling from? 913, where are you calling from?
Hello.
Yes.
Hello. I'm calling from Kansas. I'm Geeta. I came to US in February on visitor visa. And my visitor visa expired in August 6th. I applied for extension in June 22nd through online. Till today, I have not received any information on that. And during my extension, I mentioned that I will be leaving by November 12th. But I don't know what will happen because there is no flight.
What you should do is,
if I did not get any reply from them,
what you should do is, you can file a second case while the first one is still pending. Okay. So what you will do is,
again in November, I have to file,
before
right?
November, you will make a chain. You will keep filing so that you never go out of status. Okay.
Again we have to pay and again we have to
pay
file
for
it,
sure.
right?
Yes, ma'am. They get you coming and going. That's for sure. Okay.
Okay. One more thing. If I want to leave the US by before their approval or before their information, can I leave?
You can leave. You're not a prisoner here.
If I want to leave by Vande Bharat,
you can leave anytime you want, even when the cases are pending. Just remember to keep some. Hang on,
because they send me a mail that you have to wait.
Let me finish. Let me finish.
Yeah.
Make sure you keep proof that you had filed for extensions. Okay. And when you leave, your case is considered to be discarded. That's okay. We don't care because you already left.
Okay.
So no worries.
Okay. Okay. And one more thing, like if I want to leave before 12th, I have to leave, right?
You can leave anytime you want. I just said that. Okay.
Okay, because I mentioned
Ma'am, it
in
doesn't
the
matter what you
extension that
mentioned.
November
You can
12th
leave
I want
anytime you
to.
want. Okay. You can leave today, tomorrow, anytime.
Okay, sir.
Good luck.
Okay. Is there any formalities that I
No
need to do?
formality. Just leave.
Okay, sir. Thank you very much. Okay, sir. Thank you very much.
You're welcome.
Thank
Good
you very
luck.
much, sir. Thank you.
Okay. Area code, let's see, 248. 248, where are you calling from?
Hi, good afternoon. Hi, good afternoon, Rajiv. I'm calling from New Jersey. And my question is regarding the Perm application. So the only information I have is there was one of my initial Perms which was back in 2008. And the information I have is the case was denied, and after that my employer had filed another Perm which I have the priority date associated on 2011. Is there any way to capture the priority date from the old Perm case, even though I'm not with the current employer and they are not ready to release any information related to the denial?
First of all, a denied Perm or I-140 gets you nothing. Second, a Perm approval alone does not give you a priority date. I-140 approval does. Okay? Good luck.
That answers. Thank you very much, Rajiv.
Okay. Area code 805. Where are you calling from? 805. 805.
Hi, Rajiv. I'm calling
Illinois.
Illinois.
Okay. Go ahead.
So this is about the current downgrade. My son is 20 years old. He's in college. He's on H4 status right now, and next year he will age out because he turns 21. So I was thinking of including him in the new I-485 the downgrade process. Is there any issues with that?
Well, like I said, I looked at this. USCIS website tells you their approach is they will consider your son to benefit from Child Status Protection Act only if your final action dates, his final action or your final action dates become current while this 485 is pending. Your son will not be protected through CSPA based upon the filing dates. Okay. That's the only downside.
So then he will
age out, and you can apply for his green card as the unmarried son of a green card holder. Okay.
But then
you're gonna have to hurry this along.
So he is currently planning to apply for his change of status to the F1, right? So I will continue with that process.
Yeah, I think
so. It's recommended.
I think you could do both. Do his F1, and do 485. Now it becomes doubtful whether they will give you the F1 when the 485 is pending. But for children aging out, they usually do. It's not guaranteed. But he can go to school on the pending 485, no question about that.
So when will the CSPA become an issue? Because you're saying he will not qualify for a green card because it was filed before the final
action date. So the CSPA
date?
works like this. The CSPA says you must file 485. I'm just making it simple. You must file 485 before he turns 21. How do you calculate his age? You give him grace period of the time the I-140 was pending. So if he turns 21 today, but your I-140 took 6 months, so he's got 6 months added to the grace period. As long as he can file, as long as his final action dates become current before he turns 21 with this formula, he is protected and he will get his green card as your child. But if he turns 21 or over, he won't get it as your child. It's complicated. I don't have time to go through it all. But that's the study it.
Okay.
Yeah.
There is. Yeah, I understand that, but there is one more twist to it because I had filed 485 like 10, 13 years ago, but that petition was denied after 2 years by USCIS. Can that period be considered for the CSPA?
I don't think so, but I don't know for sure. CSPA has many layers. I'll have to look at the law. I don't know the answer off the top of my head, but my instinct says that probably is not going to help you. Okay.
Oh, okay.
Good luck.
All right. Thank you.
Okay, guys, I have to go. We've got, let's see, just 2 more questions. Okay, good. I'll take these 2 and then we are done. Area code 612. 612, go ahead, please. There are actually 2 612s. 612, 615, go ahead. 612, 615.
Rajiv, I appreciate.
Yes, sir.
Rajiv.
I can hear you. Where are you calling from?
Rajiv. I'm calling from Blvd. I'm sorry to interrupt in between.
No problem.
I appreciate all your extra efforts today you are making.
No problem.
Sir. Just a very, quick question onto this EB2 and EB3 downgrade, right? So I am working into, same client since about last 10 years, and it's a full-time opportunity. Client is agreed to, doing the concurrent processing into EB3 after, explaining them few times. So, but there was a catch, you pay for the 140 and we take care of the 485, which is reasonable. Which is kind of.
I think that's a
because
that may be a little bit illegal because I-140. Yeah, I-140 you can reverse it. I-140 is considered, again, I don't know if this is true, but traditionally I-140 is considered to be the employer's domain because it's their usual business expense. I-485 you can pay for all the way. That's not a problem.
So company has decided saying that, you are going into repetitive, so you pay for that, we take care.
Yeah, tell them I don't want you to pay for 485. That's a lot more money. That's thousands of dollars more. I'll pay for the 485, you pay for the I-140.
Okay, excellent. Let me talk to them. So now the question is, sir, my EB2 priority date is about 8 months away, looking at the action date right now, not the final action date. And if I am doing this downgrade and consider about 3-4 months looking at the potential filing logs will happen, it will take for the 140 receipt generation before we go into the premium processing. And I heard yesterday, now we can go for 485 as well into the premium. What the law has been updated by USCIS yesterday. Is that
they are allowing you to premium a lot many more cases, yes. But it's not been implemented yet.
Okay. So next 3 months, because I'm not sure how exactly will that need the logs and receipt generation and all this stuff, right?
Look,
and no one
if your case is solid, I would file the downgrade now. Okay?
Excellent. All right, that is solid, sir, because it's been kind of straightforward.
Good luck to you, sir. Yeah.
And if just last one, if you have 1 minute. So last one, if I'm filing into EB3 and by the time my EB2 485 as well get current, and I can move into filing that one as well, although I had filed into EB3 485.
I gotta run. I gotta run. There are more people raising their hands. I'm not gonna have time.
I will send you email.
I'm not gonna have time. No, talk to your own lawyers. Don't ask me questions your lawyers can answer.
Thank you, sir.
So, talk to your own lawyers. It's not that complicated. This part is easy. Okay. Good luck to you, sir.
Okay. Thank you, sir.
Okay. All right. So, guys, don't keep raising your hands. I told you to cut it off. I'm not gonna be able to keep answering questions the rest of the afternoon. I'm trying my best. But you just keep coming in and raising hands. Don't do that, please. I'm running out of time. I got other things to do. So, last 2 questions. That's it. Not doing any more. Okay, let's see. Area code 61. No, this is 832. 832, go ahead, please. 832.
Hi, Rajiv.
Hi, Rajiv.
Can you hear me?
I can hear you
Can you
very
hear me?
clearly. Go ahead.
Yeah. Yeah, Rajiv.
Yeah. Yeah, Rajiv. So I have a
EB2
EB2 with a priority date of 2012, and since the dates are changed, which is EB3 2015. So my employer is ready to support. Of course, I'm so now the situation has changed. I had to travel back in India. So what I want to understand is that what options do I have? Can I do CP? Because I talked with my attorney, he said, yeah, let's go ahead and do CP. And then since he is the same attorney who did my 140 in 2012. So with this combination, the employer is ready, the attorney is okay, but me being in India, do I have an option of taking the advantage of this 2015 EB3, do a downgrade?
You have to be in USA to take advantage of that.
Okay.
Okay.
Okay. Yep.
All right.
Good luck, sir. Your wife.
Okay.
All right. Okay.
Hang on. Your wife has a question.
Just in case if EB2 go ahead and get current for us, like if this is 2012, then is it okay for us to file from
Here is how
India?
it works. If you want to convert your case to consular processing, which means you want your green card while sitting in India, there have to be some additional formalities normally that you have to do in USA. I think it's Form I-824. Talk to your lawyers. It's not automatic. Okay. Make sure that your case doesn't require an 824. If it does, file 824, convert your case to consular processing. It'll still take about 8-9 months for it to be processed. And you can always reconvert to 485 if you come back to USA. That's easy. Converting to consular is time consuming. Converting back to 485 is very easy. Okay? So talk with them, get the 824 filed if necessary.
Okay.
All right?
Okay.
Good luck.
So
just on that, Raji, I'll not take a lot of time. You talk about 824. It says that if the attorney is giving those signed documents,
certified copies anymore.
Okay. All right. Okay.
Good luck.
All right. Okay. All right. Okay. Thanks, Raji.
Thank you.
Yeah, they haven't accepted attorney certified copies in years, as far as I know. So, last question, area code 612. Where are you calling from?
I'm calling from
Minneapolis. I was hearing this conference, all of them. So I understood that, if from the date we came into US, we need to have our full pay stubs because everything is checked after filing I-485 or applying for green card. There will be a problem if my current employer did not pay me for like couple of months, and then they during the I-485 process, will there be any problem?
Probably not. I'll tell you, there is a section of law called 245K as in kite that protects people. First of all, it applies only from the date of your most recent entry when you filed 485. So let's say you went outside USA in October, came back October 15th. Anything that happened before that, out of status, etc., is forgiven. If after October you were out of status for, let's say, 160 days, that also is forgiven for your 485, up to 180 days. So generically speaking, that's how it works. But do not lie about it. Tell the truth. Whatever happens, you should be able to deal with it, but discuss with your lawyers if there are any specific issues. Normally, you are well protected if you tell the truth. Okay?
Thank you.
Good luck.
Thank you.
Hey guys, thank you so much. I still have 3 hands up. I can't. I have to run. I tried to answer everybody's questions. I will see you again in about 3 weeks or so. unless things get a little bit more in hand. In that case, we'll resume. Good luck, everyone. Good luck to all of you. And I hope that we see a big change in the administration. That promises some good things for immigration. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.